Hi everyone, welcome to the SEA Student Lecture Series for 2020. And because this is a law sharing series, I will be talking more about tort law, and it includes a certain section of tort law, which is the objective and subjective tests, as well as an overall introduction to what tort law is. So this is a rough contents page of what we're going to talk about today. You can just see, but basically I'll just take you through everything later. Before that, I would like to do a bit of a self-introduction. So I am a rising third year law student, which means I am going into my last year next term. Before the University of Bristol, I was previously from Catholic Junior College and LLB College, Brighton in the UK, where I did my law foundation. In terms of co-curriculars, I was the former president of the MSSA, which is like the Malaysian and Singaporean Students Association. In terms of law co-curriculars, I was a member of, I am still am, a member of the UBLC, which is the University of Bristol's Law Club, and then Law Clinic, where we do pro bono work. And I think that my favorite place in Bristol would be either Spoon Gelato or Mrs. Potts Chocolate House, which are nice cafes in Bristol. Also, the backgrounds that I'll be using in my presentation are all pictures of Bristol. So yeah. Before I'll be presenting about law, I would like to talk about why personally I chose law, or why you should choose law for that matter, because a lot of people tend to ask these kinds of questions. So firstly, I personally preferred language-based subjects compared to science and math. But delving further into the thing when I actually learned about law in my foundation and subsequently in Bristol, I found that I wanted to do pro bono work to help people. So there are opportunities in Bristol, especially through the law clinic and everything in Bristol, to do pro bono work to help people. They're also very interesting cases, mostly criminal, but also a lot in tort law, which I'll take you through later. Also, the modules in Bristol vary starkly in terms of content. So there are no or very little overlapping kind of topics. So if you like a very wide range of things to learn, then I guess this is for you. And I think the most important thing is that it helps, like learning about law develops your skills that are transferable into career options later. The skills include like critical thinking, advocacy, and I think most importantly networking, because you do have to talk to your clients later on when you become a lawyer if you choose to. And last but not least, I find law work challenging, so it's a very fast-paced kind of thing, but it's also quite fulfilling. So yeah. So I'll take you through the key terms of objective and subjective tests in law. It's a general definition of what this kind of means before I focus more about objective and subjective tests in tort law itself. So the objective test, so what is it? So objectively, when you talk about it, like in a layman term, an objective test means that a person is not influenced by their personal feelings or opinion, and you need a minimum degree of care and skill that a defendant should exercise. So I would like to share a bit on it's a kind of a interesting kind of term. They use the man on the Clapham omnibus to kind of describe what an objective test is. So in 1871, when this was first introduced by a judge, the Clapham omnibus just means that it's the most popular route they were running in the town centre in London, and omnibus is just their way of saying like public transport. So like it's their bus route basically. So what an objective test just means is what would a reasonable human being do. So it became known, I mean, besides the man on the Clapham Omnibus test, it became known in the modern times as the reasonable man test. And then a subjective test is just the opposite of that. In layman terms, it means the person, the defendant or the claimant, is highly influenced by an individual. And in tort law specifically, there are certain factors that can make judgments highly subjective, which means the judge will choose to use the subjective test instead of the objective test. These are the 5 main criteria judges and lawyers alike have classified these cases under. So I'll just briefly go through them, and then later we'll delve more into the specific examples in the PowerPoint slide. So the first one will be professional standards. In tort law, mostly they're talking about doctors and nurses, so judges think that because these doctors and nurses are more professional in their job, so they should be held to a higher standard compared to a reasonable man. The second one would be claimants and defendants' disabilities. So sometimes claimants and defendants will have disabilities. So according to the case and according to the case facts, it would mean that the threshold for judging the person would either be higher or lower. The third one would be age. So sometimes people are a lot younger than 18, which is like the normal age which people would judge as adults. So in terms of children, they would probably be judged at a less harsh, they would be given a less harsh sentence, or not even a sentence at all, because of them being a minor. The fourth one would be any protective measures taken. Sometimes when firms, employers mostly, because these cases happen in employer-employee cases, so sometimes when the employers kind of take enough protective measures, then they will not be liable for any injuries that the employees sustain. And the fifth one will be social utility. So this one's a bit more complicated in a sense that it happens really rarely, but what happens is that, for example, you are rushing to a scene if you're a police officer or a firefighter and you get hurt somehow. Sometimes, and then because of an injury, you sue your employer. Sometimes the employer is not liable because the social utility of helping someone, or like not taking enough measures to protect your employer, taking enough measures to protect you, is outweighed by the needs of the person getting hurt. So if you don't really understand like what I mean now, I'm sure the cases later will kind of explain it, because every case is unique. And if you still don't understand it, and you can ask me questions about it. So I'll just move on. Generally, I'm going to explain what is tort law before I use the objective and subjective tests and explain where that falls into tort law. So what actually is tort? Tort is derived from the French word for wrong in the law of civil liability for wrongfully inflicted injury. So tort aims to bring back the person who is injured to his original state, kind of by compensation. So as I stated in my slides, the offerer must pay, which means the defendant, if there is a moral wrongdoing. So the defendant has to pay for what injuries inflicted on the claimant or the person who got hurt, basically. So I've listed the number of criteria someone must meet to kind of bring about a tort law claim against someone. So, and this is how normally the law school will teach tort law in, like the kind of steps the law school will teach us in. So the first one is duty of care, and it was established in the case of Donahue and Stevenson. It's a very interesting case in the sense that, or rather, it's a very unique case in the sense that, so Mrs. Donahue was drinking a glass of ginger beer in a cafe, and when she poured the ginger beer out into a cup, there was a dead snail in her ginger beer, and basically she sued the ginger beer company for not taking enough steps and inflicting her with sort of mental injury because she sustained PTSD after that. So actually the rule was being termed as the neighbor test. And in the case, it was cited that the ginger beer company ought to have taken reasonable care to avoid acts and omissions, which was the snail in her ginger beer, which you can reasonably foresee would likely injure your neighbor. And she won in the case because the court held that the ginger beer company ought to take any measures to sort of prevent that act from happening. So that is the duty of care bit. So once you have established this, we move on to the breach of duty. So let's say if the defendant owes a duty of care to the claimant, which means the person claiming, you need to see whether there is an actual breach of duty, which is whether the defendant, which means the person being claimed against, failed to take any care to prevent the harm. And that is when the objective and subjective tests fall into. So they use these tests to kind of weigh the case and the case facts to see whether there was an actual breach of duty. Because if the level of breach is too low, then the defendant will not be liable. And then the third one would be factual causation, which I will not delve into for today. But basically, after establishing there's a breach of duty, you need to establish causation, which is just if the action didn't happen, would the injury still have occurred? And there are, of course, like many cases for that, which you will subsequently learn in law school. And then the fourth one would be defenses, which is if an injury is really sustained, sometimes the defendant will use defenses to kind of mitigate their sentences, to say that, like, oh, the claimant brought this upon himself, or the act was clearly illegal, so the claimant can't claim against him and stuff. So sometimes the sentence will be reduced totally, or sometimes it'll be reduced quite a bit. But yeah, I'll move on to objective and subjective tests in tort law and the cases relevant. So I'll deal with the cases under objective standard of care first. So the positives of using the objective standard of care would be that basically you're judging the person, so the defendant, without any moral fault. And as AP Herbert said, as you can see in the slides, that would mean that this is an ideal standard because you don't judge a person by his or her flaws. You judge him or her by an objective standard, which is what most people will agree. So in terms of morals, because these people that I've listed are sort of philosophers, so they think that this is the correct standard of care. But yeah, when the law school teaches tort law, we always start with objective standard of care first, and then we move on to the subjective standard of care. So the first case, the landmark case that the law school will teach is Vaughan and Manlove in 1837. So the facts would be, the defendant, he built hay next, he was sitting on a rick of hay next to the claimant's barn, and he fell asleep while smoking. And then the hay caught fire. And then instead of actually calling the firefighters and everything, he went back to sleep. So the fire spread to the barn and burnt it down, and the claimant obviously sued because his barn was ruined. And it was using the objective standard of care, the judges held that the defendant was found negligent because he was being judged to a reasonable man test. And in 1837, there were many cases of barns or infrastructures being burned down because of hay ricks catching fire and everything. So the judges held that as a reasonable man, he would have known that hay ricks were known to be set on fire and it would ruin infrastructures nearby. So in that way, he was liable. Another case would be Nettleship and Weston in 1971. So the facts were that the defendant was a learner driver, and then the claimant, who was a driving instructor, was in the driver's seat. So the defendant panicked while driving on the road and hit a curb. And this obviously injured the claimant and he sued her. Even though the defendant said that she was just a learner driver, the judges found her negligent because by the reasonable man test, because no matter if you're a learner driver or a normal driver, you're still driving on the road. So you ought to know road safety, and she was still being judged by a reasonable, like what a reasonable person would do, and hence she was negligent in that way. So yeah, I hope you understand like what the objective standard of care means through these cases. And then I will now move on to what the subjective standard of care standards are. So firstly, as I introduced just now in the previous slides, the first kind of type of case under subjective standard of care would be the professional medical standard. So what this means is that, as I explained just now, because you are a professional and you're either a doctor, nurse, or a consultant in a hospital or something, there are many cases whereby bad things happen or accidents happen in or medical malpractice happens in the hospital and everything, and the judge says that you cannot be held to a reasonable man standard because you ought to know better because you're a doctor. Yeah. So the first case is Bolam v. Fryan, as you can see, in 1957. So what happened was that the claimant, so the patient, went through electroconvulsive therapy and the doctors didn't give him any relaxant drugs. As a result, he went through the therapy and he fractured his jaw because it was very severe. And as a result, he sued the hospital saying that the doctors ought to know better to give him relaxant drugs. So it was held under these standards, professional standards, where the court developed this test called the Bolam test, because after this case, as a precedent, which means like cases after this should follow this judgment, saying that as long as the doctor's practice was in, he should have known better. But in this case, there was kind of a loophole in a sense whereby the judges said that if a body of doctors agreed with his action, then he would not be in breach. So supposedly, because he was a doctor, he would have been held to a higher standard of care. But because other doctors in the board at that point in time agreed with his practice of not giving the patient relaxant drugs, so he was lucky, and hence he was not in breach of, he was not liable for the patient's injuries in this case. Similarly, for the case of Bolitho and Hackney Health Authority, City and Hackney Health Authority, 1998, basically the patient again was breathing abnormally and she was brought to the hospital. The doctor did not respond when summoned because basically the call button on the bleep was low in battery, the child died and the mother sued. So using Bolam as a precedent, the doctor was not in breach because the child would still have passed if the doctor had responded, and this would mean that the mother's claim was illogical. So yeah, basically I'm trying to say that under professional medical standards, doctors and nurses will still be liable if the injury happens, if it's not, if other doctors don't really agree with their practice. I'll just move on to claimants and defendants' disabilities in this sense. Okay, so the sorry. So the first one would be Paris and Stepney Borough Council in 1951. the first case will deal with the claimant's disabilities, and this will show how the threshold of liability will be increased or decreased by the judge. So in this case, the claimant had lost one eye in war, and he was employed in the garage and was not given any goggles. So a splinter got into his good eye, and then it blinded him. So now he's completely blind because of the accident. So his employer kind of said that we actually don't give any employees any goggles, so he should not be getting goggles. Basically, he should not be special. So I'm not liable for like his injuries or anything. But the judges used the subjective test and said that although none of the other employees got goggles, he should have. And as I said, standard of duty for this case was higher because of his disabilities. And the second case would be Mansfield and Weetabix. So this is when the defendant, so the one being claimed against, has a disability, which would lead to his sentence being kind of lowered because of his disability. So in this case, the defendant drove his lorry to a shop, causing damage to the claimant's shop, and obviously the claimant sued. So at the time of the incident, the defendant suffered from a malignant insulinoma, which is basically a health condition which causes him to go into hyperglycemic state. And he's unaware of this, which caused him to crash the car. And as a result, the judge took this into account and said that he was not in breach of duty because he didn't know it would happen. So this would be unfair to kind of charge him for that. I'll just move on to minors in terms of age. So as I explained just now, basically if you are kind of younger, your sentence might get reduced because you are not the reasonable person, you're not a reasonable adult in the law's eyes or in the judge's eyes. So the first case would be Mullin and Richards. The case talks about two 15-year-olds fighting, and then with rulers. One of the rulers snapped and then fell into the eye of another girl and hurt her. And obviously the victim kind of sued. The judge held that there was no breach of duty because she can't be held to the standard of care of a reasonable man. Instead, she should be held to the standard of a 15-year-old girl. And the judges said that basically she didn't know what she was doing because she was really young and should not be charged at all. Similarly, in the case of Orchard and Lee in 2009, a 13-year-old boy ran into a lunch lady and then caused her to sustain some injuries, and then she sued the boy. So using the case of Mullin and Richards, the Court of Appeal noted that the standard of care should be held to the standard of a boy his age, so a 13-year-old, instead of a reasonable adult. And hence he was not liable for the lunch lady's injuries. Yeah. So I'll now move on to the last point, social utility. As I kind of tried to describe just now, social utility means that if you're doing good for society and you sustain injuries in your actions, you can't sue, or it'll be so basically the social good you bring and then you sustain injuries will outweigh you actually getting injured. So yeah, I'll explain this thing with the cases now. So for the case of Watt and Hertfordshire in 1954, the claimant was a fireman, and then he heard that a lady, so a casualty, was stuck under a vehicle in an accident, and then this required the fireman to carry a heavy lorry jack, which is basically something really heavy to help to lift the vehicle up in the accident to save the lady. So while transporting the jack to the scene, the jack fell onto the claimant's leg, causing severe injuries, and then he sued his employers for not taking measures, basically. And while he got injured, his employers were not in breach of their duty, because in that situation it was a very fast happening kind of situation, and the utility of the claimant's conduct, which was like to move the heavy lorry jack to save a life, outweighed taking precautions, outweighed his employer taking any precautions, and that is how he got hurt. So as a result, his employers were not in breach of duty. And the second case would be Ward and London County Council. So in this case, similarly, this is not similar for, so sometimes, let me just rephrase everything I've said. So for the first one, the employers were not liable, but then they cut, so the second case is different from the first case in a sense whereby even though social utility plays a large part in these kind of cases, I would say that there comes a time where you should draw the line, where you can actually claim against your employer or claim against the defendant when something bad happens to you, even though you are trying to help or you're performing action which is gonna help the society, for the greater good of the society, basically. So in this case, a fire engine driver injured a pedestrian while running a red light. And when he was charged, he said that, oh, I had to run the red light because I was rushing to the accident and I couldn't stop, basically. But the courts held that the fire engine driver was liable for negligence, because in this case, they said that it was a known rule that he should have slowed down, and then slowing down actually at the red light would not have significantly affected the outcome of the emergency. So even though it was an emergency, he should have drawn the line somewhere, and he shouldn't have done such rash acts to actually like not slow down at red light and like knock down a pedestrian. And obviously he should not have the complete freedom to do anything he wishes to do so. So there is a limit to what you can do when you are trying to help the greater good and you injure someone or are being injured. So I'll move on to the last one, which is sufficient measures taken. And I'll go through these cases and then later there's a quiz, because some of these cases are quite similar in terms of case facts. So the first case for sufficient measures taken, as I explained just now, is that if your employers take sufficient measures, they can't be liable for your injuries. So Bolton and Stone, Ms. Stone was hit by a cricket ball and sued the cricket club near her house. But the cricket club said that they had a fence surrounding the pitch, which was 17 feet high. So that's really, really high. And in 30 years of operating, it was reported that the ball had been hit out of the vicinity only, that means out of the fence, only 5 to 6 times. As a result of these measures taken, the court held that there was no negligence because the club had done enough to prevent negligence by putting up the fence and trying to prevent any balls from going out of the vicinity. Similarly, in the case of AEC and Latimer in 1953, the facts were that the claimant was working in a factory when he slipped and fell due to the floor being slippery because of wet weather. He sued the factory for negligence, saying that the factory should have done more to prevent this from happening. However, the courts held that his employer was not liable because the owner of the factory had actually put cardboard on the floor to prevent people from slipping, and also put signs to warn employees of the wet floor. Also, the claimant demanded that the factory close during wet weather, but obviously that was quite illogical in the court's eyes because, factory still needs to open when it's raining, basically. So yeah. Okay, now it's quiz time. So actually this is a real case which happened, but I haven't shared the judgment, and I thought it would be kind of fun to bring you through the case facts, and then it's basically a yes or no question, and we've set up a poll option, so you can vote whether the cricket club in this case was negligent. So I'll just bring you through the case facts. So the claimant bought a plot of land and built a house, and there was a cricket club or cricket ground 18 meters from the house. One day the cricket balls kept being hit into the land, and it caused several damages to the house, and then obviously risk of personal injury, which means like risk of the cricket balls hitting the people in the house or walking outside the house. In terms of measures, the cricket club erected an 8 feet fence, but the balls kept getting hit into the area. In 20 weeks of one cricket season, 6 balls were being hit into the surroundings of the house. So obviously the claimants who bought the plot of land and built and who owned the house sued. So I just want to ask if you think what you think, and whether you think the judge held would if the cricket club was negligent or not. So if you see in your polling option, just vote whether you think the cricket club was negligent or not. Yeah. Yeah, we'll just wait a bit. Okay, I think I've gotten several results. So all of you said that yes, you think that the cricket club is negligent. And sorry. Yeah, and you're right. Actually, this was the case of this was the case of Miller and Jackson. Sorry, just forgot the name there. But basically, yes, the cricket club was actually, like you said, was liable of being negligent in terms of letting like cricket balls being hit out of the club and injuring people, because they did cause damages to the house and then obviously hit people. So this case of Miller and Jackson was actually used to juxtapose the previous case of Bolton, saying that even though there are similar case facts, you do need to take necessary measures into hand as an employer, or as basically as a defendant in general, to prevent injury from happening. And and it was held that the cricket club was negligent. So this comes to the end of the law, kind of bit on tort law and objective and subjective tests. I hope this was quite informative, and then I'll just move on to sharing more about my life in Bristol and in law school in the UK. So before that, these are the Bachelors of Law requirements for the University of Bristol. Okay, so I'll just bring you all through all these points. Basically, because both students and like the international office, I'm sure are being asked, so what do you have to do, or what are the requirements of getting into law school, basically. So in the UK, course duration for the law degree would be 3 years, and then you can choose to do a master's after that, which would be 1 year. But that's totally not, that's on you. So like, it's on personal preference, basically. So yeah, you will graduate with a Bachelor's of Law after 3 years. The cost per year will be 20.1 thousand pounds, and this is excluding accommodation and living fees. This is the estimate for this year, and it will depend on the year you go into law school, basically. Do need to check the website for Bristol. In terms of A-level requirements, it's either A star AA or A star B. yeah, this is the UK A levels. Because Singapore, if you're doing A levels, I'm not really sure like what kind of curriculum you're going under, but for Singapore A levels, you just like move your grade one grade higher, because basically the UK has A star and Singapore doesn't. For IB, it's 38 points or above, and if you did a foundation in the UK, it'll be 85% average or more. And in terms of English things, if you go in straight, it's O level or GCSE English. Or if you choose to take an IELTS, if you do a foundation, it'll be 7.5 average. And before you apply, they will ask you for your LNETs, which is this critical thinking test that all law students have to take before they go into law school. And I think it varies year to year, but I think for Bristol, you need to have, it'll be upon 40, and you need to have the average for the year. Yeah, and deferred entry is welcome for guys if you have to serve NS. Yeah, the last point, everything here I listed is all subject to changes by the university. So for your year, if you choose to go into Bristol, you do have to check the requirements again in the University of Bristol page. So yeah, I'll share more about my life in Bristol. Firstly, the academic, and then the next slide would be like kind of more social, co-curricular activities kind of things. And obviously there'll be more pictures in the next one. So how the modules work in first, second, and third year is that first year in Bristol or anywhere in the UK, if you do law or any other subject, it will not be counted, but you do have to kind of get a 2-1 or above. So in terms of points, there'll be 60% and above to get a good internship, which I would recommend, obviously. In second year, it'll be 40% weightage towards your final grade, and then third year, 60%. Personally, I would recommend doing law in Bristol because of your ability to choose optional modules in your second and third year. So in your second year, you'll be able to choose 3 optional modules, whether law or non-law. So for mine, I took medical law, company law, and advanced tort. And some of my friends did like languages or something like business. And in third year, you get to choose 4. So mine are something like employment law, sex gender law, and corporate law simulation, and commercial. Also in terms of tutorials and lectures are the big ones whereby you sit in a lecture hall with your cohort, so 300, 400 people, and then tutorials, which is 5 every fortnight, so 5 every 2 weeks. And obviously tutorial groups will be a lot smaller, about 6 to 8 people. Yeah, and I find if you are quite concerned about mental health, actually the university takes mental health very seriously. We do have counselors, and that you can go find in the school. And in terms of, we have this thing called home tutors, whereby when you're in year 1, you have a class of about 6 to 8, so like a tutorial kind of thing. And you have home tutors, which are teachers, which you can kind of email if you have any questions that are not academic at all. So like any welfare matters, you can email him or her, and they will stay with you for the whole 3 years you are in law school. One good thing about studying law in Bristol is also that I noticed that the professors are very qualified. When you're studying law in Bristol, you have recommended book lists and everything, and the professors do write their own textbooks. So yeah, you'll be like, let's say like for mine, I was studying Tort Law in first year, and textbook was written by Paula Jilka, who's our Tort Law teacher who lectured us for actually what I just talked about. So like she did talk about negligence. Yeah. Law buildings, the main one will be Wills Memorial, the big landmark you see in Bristol. If you research anything about Bristol, Berkeley Square, Victoria Rooms, and yeah, etc. You'll get to know like once you get to Bristol if you choose to. In terms of co-curricular law activities, you can join stuff, activities organized by the law club. Actually, the law club in Bristol is the biggest one in UK, and it has a very long history. and other law societies like Bar Society, Medical Law Society, Lawyers Without Borders, yeah, etc., etc. These will give you opportunities to do mooting and negotiations competitions to build your advocacy skills. And obviously, if you join these, also the law club will post openings, so open days to very large firms in London. So they'll take you down to London, and then you go and network with the other solicitors in these big law firms. And if you're a bit shy like me when I first started out, it'll give you time and the opportunity to talk to these solicitors to see what working in like a big city law firm is like. Yeah, to give you the confidence to talk to people. So, and I think one other good thing about studying law in Bristol is that there are many other international students doing law there. So like people from like Europe or people from Africa, and a lot of students from Southeast Asia as well. So yeah, this is my life at Bristol, and there's a social bit. So a good thing is that, as I mentioned just now, we do have the MSSA, which is the Malaysian and Singaporean Society, and we have a lot of activities and things year round. So if you can see my clicker, this is the Chinese New Year dinner we kind of organized for students this year. Have a lot of fun doing that. The one in the middle bottom is actually the law ball, the UBLC, the law club organized. Yeah, they have 2 every year if COVID permits this year. But yeah, not very sure about this year. But yeah, we do have it every year, and these are sponsored by the law firms that they partner with. This one would be Halloween. And this one in the top right would be this special thing which the MSSA does, which is MS Night, which is a play written and put on. Everything is produced and directed by students. Yeah, and this is our suspension bridge, very popular in Bristol as well. Yeah, and one year it was snowing in my first year, and obviously if you go overseas to the UK, you study in the UK, you get to travel a lot. Not so much now, but like when COVID dies down, because you're just a train or a short flight away from countries such as France or even Switzerland or Italy. So yeah, that is actually Italy. So yeah, I hope you like my presentation about tort law. I hope you understand a lot, or maybe just a little bit more about tort law and law in general in Bristol, and as well as the opportunities and the environment of Bristol. Yeah, and obviously if you have any other questions after this talk, you can contact the University Southeast Asian team. Contact Sumi at this email, the Instagram for the Southeast Asian team at Bristol, yeah, and my personal email. If you, yeah, just feel free to email me if you have any other burning questions about law or what it's like studying in Bristol. Yeah, we can open the floor now for any questions and answers if you like. Yeah, don't be shy. Any questions are good. Yeah.
Thanks so much, Regina. That was so informative. And now we all know how to avoid getting sued for negligence. So, students, have you got any questions? Just feel free to post them in the Q&A. Let's start with some FAQs, questions I always get asked for law. So students always ask me, can I work in the UK after I graduate, and how does it work? How do I start working? How do I get into practice in the UK?
Okay. Right, so in the UK, there are actually 2 routes if you don't really know. So if you're Singaporean, lawyers in Singapore either work in the office, and then they will actually go to the court as well. But it doesn't work like that in UK. So there are 2 routes. So you either have, like, to break it down simply, it's a solicitor route and then barrister route. So barristers are the one who do like criminal work, and I don't know if you've seen shows or anything, but they wear the robes and they have the horsehair wig. Yeah, those, what you need to do is that you will have to study something called the bar. And after you've passed and you've done you have to shadow a barrister in one of the inns in London. Yeah, then you can be a fully qualified barrister. But mostly Singaporeans will take the LPC route, which is to become a solicitor. So you're kind of working in the office. It's a lot of corporate work. So like corporate mergers and acquisitions, how you buy a firm and sell a firm and help clients do that kind of stuff. I don't know if you've seen Suits, but kind of like that. But this is the UK version. Yeah. So what you have to do is you have to take a legal practice course after you graduate from law school, and as Singaporeans or as international students, we do have to get a working visa, and if you get into these law firms, they will sponsor your visa and they'll pay for you to do the either accelerated LPC, which is 6 months, or like the full LPC, which is a year. After you qualify that, you train with the firm as well. You do things, sorry, they are called seats. So yeah, basically you train with the law firm and then you become a qualified solicitor. So yeah.
Thanks. So they basically have to decide whether they want to be a lawyer from Suits or a lawyer from The Good Wife.
Yeah.
We've got another question. What's the accommodation like at Bristol?
It really depends. So in first year, I would recommend, or most people live in the student dorms. So there are many in Bristol, but they are being broken down into either the city centre accommodations or the ones in Stokes Bishop, which is slightly further away from the city centre, but you have a bus there. There are a lot actually, but maybe I'll just share about the one that I stayed in. So I stayed in Orchard Heights, which is actually quite near the law school. It's about 10-15 minute walk from Wills Memorial. I think it was really nice in a sense that like Orchard Heights had a very, very big common room, and in my first year, a lot of people I knew lived there, or people I made friends lived there. So we had a lot of like bonding activities there, like potlucks and everything. Like even Halloween. If you can see in my Halloween picture, that's actually I'll just go back. That's actually the Orchard Heights common room. Yeah. Yeah, in terms of like rooms and everything, I think it's quite nice in Orchard Heights. There was it's like a flat, so you share a flat with, I think mine was 5 other people. You have your own room, own toilet, but you have to share a kitchen, and I think that was quite nice in a sense. Oh, I would totally recommend living in student dorms first year, because you get to meet a lot more people that way. Like I met like people from countries like I haven't been to. Yeah, in first year you'll just meet them like when you're hanging out in the common room and everything. In second year and then going to third year, I chose to move out to a student accommodation, but not owned by the school. So it's one called William and Matthew. So I chose to have my own studio, which is having a kitchen in your room as well. Yeah, or some of my friends chose after first year to move out and move in with their friends. So they rent a flat and yeah, they live with their friends. So same thing, rooms, but own room, sorry, but sharing a kitchen. Yeah, and I think living in Bristol is a nice thing, because Bristol is, I don't know whether I've mentioned it already, but I like Bristol because it's not as busy as London, but it's not as quiet as, I would say, places up north. So you do have like the hustle and bustle in the city, and then if you want somewhere quieter, you can go to places outside the city. Kind of. Yeah. Hope that kind of answers your question. Yeah.
Thanks, Regina. We've got time for just a few more questions. So if there's anything that you've got that you really have to ask now, now's the time. But another question I get a lot is just, do students get much work experience during the degree? And can you give us some stories from your own experience, Regina?
Yeah, sure. Thanks, Sumi. Okay, so like for work experience, they don't really teach you any work stuff. I mean, because they have to teach you like the basics of law and everything in law school. But there are lots of clubs and societies. So as I mentioned, the biggest one in Bristol for law would be like the University of Bristol's Law Club. And it's a very, very big organization, society. So yeah, they do kind of give you opportunities. So there's this really big Facebook group and they add everybody inside. So if let's say opportunity from this big law firm, I don't know if you've so basically similarly like the big four in Singapore, there is the big five basically called the Magic Circle in UK, and all most of them are sponsors for the law club in Bristol. And let's say if they have an open day for, I don't know, this law firm called Slaughter and May, they will bring you if you sign up to Slaughter and May in London from Bristol. They'll charter a bus and everything, and you can go there and you can talk to the solicitors, find out more about their work, why they started working in London or started working in a firm, find out what you like and that kind of thing. In terms of like skills you need for your jobs, I think there are a lot of things that you can join as well. So like mooting and negotiations. Sorry if I'm not clear about like what mooting and negotiations are. So negotiations are like you have a contract and both sides want something. So you have to negotiate to come to a decision about like who gets what. Happens a lot in terms of like divorces or very big deals, like how much money goes to buying and selling a house and stuff like that. They have more kind of contracts for you to negotiate on, and it's actually a competition. So if you go to the finals, or actually I think the semi-finals, these competitions obviously are being sponsored by these big firms, these big law firms, and you have the opportunity to get to sit down with the firm sponsors, have a meal with them. You go to like the semi-finals and everything. And then mooting similarly is like advocacy, but it's like a mock court trial kind of. So so you're trying to advocate for a point of law. Let's say like tort law tort law breach of duty, and you're supposed to argue your point in front of a solicitor or a judge or a student judge, kind of, if they call you in and stuff. So yeah, I think that builds up your advocacy skills. And in terms of pro bono work, if you like pro bono work, it'll teach you how to interview a client or write an affidavit, write a letter of claims. Can join the law clinic, apply to join the law clinic. Yeah, currently I'm working on a case which I have been working on for very long, but basically I have to help the client claim back a sum of money actually it's a tort law case, so it's personal injury case. So somebody knocked him down and refused to pay him. So yeah, I'm helping him kind of pay back his money from the insurance firm of the man who knocked him down.
Great. Wow.
Yeah.
So many things you can do.
Yeah.
Okay, so we have time for just the last questions. If you can answer this quite quickly, Regina. How often tutorials and lectures, i.e. what does a typical week look like?
Oh, okay, sorry. Wasn't very clear on that just now. But as I explained, tutorials are 5 times every 2 weeks. So depending on your schedule, the law school will allocate you your timetable and everything in the start of the year. But basically, it can be like 3 tutorials in one week and then 2 on the other, or 2 and 3. And then I have friends that have like crazy schedules, which are 5 and 0. But it means you have more time in like the week where you don't have tutorials and stuff. But yeah, there are actually lectures going on every day. But I would say I think it's so studying law is actually very you have to self-study a lot compared to other kind of modules and kind of other courses. So I will have, I think on average, sometimes 1 or 2 at the very least, or sometimes 4 or 5. No, I've never actually had 5. So like 4 at most lectures in a day. So it really depends on your schedule. But I think almost every day I'll have at least 1 lecture or something. And lectures in Bristol start at 9, go all the way to ending at 6. But yeah, it can be anywhere in the middle of the day. Like I have lectures at 12 and then you can sleep in kind of. But yeah, I hope that kind of, yeah.
Thank you so much, Regina. So I think it's time for us to wrap up now. And Regina, do you have any parting advice for the prospective law students who are watching this session?
Yeah, so I would say in terms of like, so to study in the UK for any course actually, you need to apply through UCAS. So I would say have a good personal statement, and I would really recommend like studying law if you are into what I explained just now, like about kind of learning more about how the law how law works, helping people and everything. And I think like as people say, as hard as it gets, I think every course that you study in university is challenging in its own way. So I wouldn't say be too scared about the work, because I think you'll get a hang of it. Yeah, and good luck for your exams if A levels or IB. Yeah.